Roe versus Wade was overturned a long time ago by the U.S. Supreme Court about 20 years after it made the Roe versus Wade decision in the Casey decision. Roe versus Wade set up trimesters. And in the final trimester, the last 3 months, the state had an interest in protecting the baby. Roe recognized that it was a baby. Didn't say the state had to protect it, but it recognized that there was a state interest, so there would be some limits. The decision itself was based on everything and based on nothing. I'll prove it to you. In the 1973 decision written by Harry Blackmun, one of the dumbest men to ever serve on the court, he cited various justices and rulings in the past that looked at the Fourth Amendment, the Fifth Amendment, the so-called penumbras and emanations of the Bill of Rights, the 14th Amendment, wherever they could look, because it was a result looking for a constitutional argument. Most of the people today screaming outside, most of the Democrats, people like Murkowski and Collins, have actually never read the Roe versus Wade decision or the Casey decision. Most of the journalists haven't read either decision. And on-the-spot analysis of the decision today was widespread, and yet none of them had read today's decision. When you read today's decisions, the concurring opinions and the dissenting opinion, they are about 1 inch thick of the average thickness of Xerox paper and well over 100 pages, more like 125 or 150 pages. This decision takes not just the justices, but federal judges at every level out of the bedroom. Federal judges, of which there are about 1,000, 1,100, give or take, have been in the bedroom now for a long time, deciding on who can do what, when, how, and where. On some cases, that's okay. You can't commit crimes in the bedroom. Acts of incest, rape, the production of drugs, conspiring against your nation. But I'm not talking about that. I'm not talking about that. The court has said, as clear as it knows how, and for anybody who is literate enough to read it, that this case deals with one matter, abortion. That it does not deal with marriage. It does not deal with contraception. It's on page 71. Alito, for all 5 justices, writes, first, the dissent suggests that our decision calls into question Griswold, Eisenstadt, Lawrence, and Obergefell. These are big privacy cases, so-called. But we have stated unequivocally that, quote, nothing in this opinion should be understood to cast doubt on the precedents that do not concern abortion, unquote. So they stated on page 66 and 71. We've also explained why that is so. Rights regarding contraception and same-sex relationships are inherently different from the right to abortion because the latter, as we have stressed, uniquely involves what Roe and Casey termed potential life. The others do not. Therefore, a right to abortion cannot be justified by a purported analogy to the rights recognized in other cases or by appeals to a broader right to autonomy. It's hard to see how we could be clear. Moreover, even putting aside that these cases are distinguishable, there's a further point that the dissent ignores. Each precedent is subject to its own stare decisis analysis. The factors that our doctrine instructs us to consider, like reliance and workability, are different for these cases than for abortion jurisprudence. What does all that mean? It means there was a building of cases intentionally by the ACLU and other groups to get to the point of Roe. And so they build it around this notion of privacy rights in the Constitution, starting with 2 contraception cases, including Griswold, moving on to other types of cases. Then, of course, Roe v. Wade, the Casey decision, which obliterates the model in Roe v. Wade and expands it further on the issue of viability. And then the same-sex marriage case. And the cases that built up to that, including Lawrence. Not to get into the weeds, I want you to stay with me here. And so what's happened is the so-called right to privacy has been the holy grail, even though that's not in the Constitution. They had to change another part of the Constitution, due process, and turn it into something called substantive due process. Again, not to confuse. And what the justices are saying here, we're not going to get into all that. We had no authority to rule on abortion, period. There's no history, there's no language, there's nothing. Absolutely nothing. We're not going to rule for it. We're not going to rule against it. We're going to get out of the business of ruling on abortion. Now, people say this upends almost half a century of jurisprudence. But what they never admit is that Roe versus Wade upended almost 180 years of jurisprudence. And that's irrelevant anyway. These men and women, they're of flesh and blood. They're human beings. They're lawyers in robes. They make mistakes. They're influenced by God knows what. And so these lower courts, these federal district courts, these circuit courts, and the Supreme Court now are to stay out of the business of abortion and leave it where it belongs.